Thank you very much. Thanks for the introduction. Thanks to all of you for coming here tonight. Thanks to Michael Goldberg, the proprietor of the Belly Up. This is an awesome place to come, is it not? Is this a great place to have a discussion? Delighted to be here, and we will try to get off the stage in time for Lucas Nelson to be here later on this evening. Yeah, you can applaud Lucas Nelson. That's fine. David Boies needs very little introduction. He has been before the country on many a famous case, one of them being Bush versus Gore. That did not turn out very well for his side, as I recall. But there have been many others. He's been involved in the Microsoft case. He's had clients, if I'm not mistaken, you'll correct me if I'm wrong, ranging from George Steinbrenner to Michael Moore. It's been really a remarkable stretch of cases, whether you've agreed with his side or not. And he has often been a witness to or a participant in history, and never more so, perhaps, than in one of these two cases that was decided this week, that was announced this week. David, I want to begin by asking you a personal question about this, because you're a prominent attorney. You get to pick and choose your cases. Attorneys are advocates. They don't always entirely agree with their clients. They don't have to. But in a Supreme Court case, you usually do. Was there something in your life, in your personal experience, your family's experience, that made you want to take this on?
I think there probably were two things. First, I've been involved in the struggle for civil rights since I got out of law school. I was in Jackson, Mississippi in the middle and late 1960s, fighting what I thought at the time was the defining civil rights struggle of that time. And beginning in the middle of the last decade, I began to recognize that the struggle for equal rights for gay and lesbian citizens was really the defining civil rights struggle of this generation. And I think if you pointed at a particular point in time, it would be when Gavin Newsom opened the clerk's office in San Francisco to permit people to get marriage licenses.
This is 2004. He was the mayor of San Francisco.
He was the mayor of San Francisco, and it was before Proposition 8. It was before the California Supreme Court had ruled on marriage equality. And he took it on himself to say that people ought to be able to marry the person that they loved. And he directed the clerk to issue marriage licenses to anyone regardless of sexual orientation. And people came. It was a great act. He deserves an enormous amount of credit because this was a time when it was not easy to make that decision. Even in San Francisco, it was not an easy decision, and it was one with a lot of political danger. And it was a very courageous decision, I think, that Gavin Newsom made. And people from all over the country and all over the world came to San Francisco to get a marriage license. And you couldn't look at these people standing in line night and day to get married and not think, what in the world are we doing as a society in interfering with that relationship? What in the world are we doing as a society of depriving them of the right that we all take for granted, which is the right to marry the person that you love?
So you believed in this cause, you believed in this issue, but then of course you have the strategic decision of which case to choose, where to go with this. You have noted, as others have, that at the beginning of the challenge to the law, and perhaps we should just review very briefly some of the complicated legal history here, after San Francisco's Mayor Gavin Newsom allowed this to happen, there was immense controversy. There were court cases in California. Ultimately, there was a ballot initiative in 2008, and by that ballot initiative, gay marriage was outlawed in California. The question was whether to challenge this. You have noted, as others have, that there were many divisions, even among supporters of gay rights, about whether to pursue this case, about whether you could go ultimately to this particular Supreme Court and win. I'd like to know if you yourself ever had any doubts about it.
Well, 3 years ago, I was here at this venue, which I think is the greatest venue in Aspen, and that's right. I mean, it's just a great venue to come and talk about these kind of issues. And I was asked from the audience, this was after we'd brought the case, but before we had even a district court decision. And I was asked from the audience whether I thought we were going to win in the district court, and I said I did. And I was then asked, did I think the case was going to the Supreme Court? If it did go to the Supreme Court, would we win? And if we won, what were the grounds? And I said at the time I did not know whether we would go to the Supreme Court or not, because there was substantial dubiety in my mind whether the Supreme Court was really ready to take this issue head on. So I said I don't really have a view as to whether or not it's going to go to the Supreme Court. But if it goes to the Supreme Court, we will win, and we will win on standing. And that's what happened on Wednesday. And
essentially, the court said that the plaintiffs had no standing.
No, the plaintiffs had standing.
Oh, excuse me. The appellants had no standing.
Yes, the people that were appealing didn't have standing. And what that means is that when you sue to enjoin a statute, you're suing the Attorney General, you're suing the governor of the state, and if they don't like the result, they can appeal. But an average citizen can't simply walk in off the streets and say, we want to appeal this decision. And the Supreme Court has been very rigorous over the years in limiting who can actually come into court and make arguments. And the proponents of the statute weren't harmed by this decision at all. Permitting other citizens to get married can't harm somebody who's not affected by the decision. And these people weren't affected by the decision at all. So they didn't have standing. And I thought that the court would recognize that allowing marriage equality doesn't really hurt anybody. And as a result, nobody really has the standing to challenge that except the officials who are charged with enforcing the state law, like the governor and the attorney general.
Didn't you at some point have a sleepless night where you wondered if the court might produce a
ruling?
Well,
I tell you, Wednesday morning, I had a sleepless early morning because this was the day that we knew we were going to get a decision. And I woke up and I was reflecting on a series of 5-4 decisions earlier in the week in which they had held the Voting Rights Act unconstitutional, in which they had restricted the right of people to sue for civil rights violations, a number of other very conservative decisions, and they were all decided 5-4. And although I had been very confident that I could see at least five votes for marriage equality, thinking about those prior decisions kept me from going back to sleep.
You mentioned that you were on this stage a couple of years ago. If I'm not mistaken, you were on this stage with your fellow counsel, Ted Olson.
That's right.
Who's Republican, who's conservative, who was on the same side as you on this issue. We were talking a couple of days ago, David, and you said something to me. You said, we became friends during Bush versus Gore. Are you aware that everyone else in the country was not making friends with people from the other party at that time?
No, and
how'd that happen?
Well, Bush v. Gore was obviously a very divisive time for this country, and I think both Ted and I felt very passionately about the side that we were representing. On the other hand, I think that when you're part of the legal profession, you recognize that the person on the other side of you, the lawyer on the other side of you, is not your enemy. He's a person that's participating in our adversarial process the same way you are. It's also the case that as you get more and more into a case, there are fewer and fewer people who you can really talk to about the case. You're so obsessed with all of the details of the case.
I mean, no one else even knows. No one can understand what you're talking about.
If they could understand it, they don't want to spend the time. Your children are bored with it. Even your spouse gets a little tired of hearing about it. And,
only a little?
And it's...
she's here. She can offer her opinion later.
She can offer her opinion. But she's very patient. But even Mary, can at some point think, I've heard this already. The only person that's as obsessed with it is the person on the other side. And so you naturally tend to talk with that person. And Ted was a lawyer who was a person of great integrity, great skill as a lawyer, but great integrity both as a lawyer and as a person. He was somebody with whom I share very little in common in terms of political outlook. We sometimes appear on television programs, and when we're talking about marriage equality, we're totally in sync, and we almost finish each other's sentences. And then we talk about something like Citizens United or Bush v. Gore, and we just go off in 180 degrees in opposite directions. But he is somebody who I very much admire. He's been somebody who I very much enjoyed working with. And he's somebody who brought to the table not only his great abilities as a lawyer, but he brought to the table the ability to try to show people by example two things. One is that you can disagree with people on lots of things and nevertheless cooperate on the things that you agree with. And you can find common ground. And even people who are very passionate political opponents can find common ground where they can work together. And I think both Ted and I thought that that was an important lesson to try to demonstrate. The second, and even more important principle, was that this was not a Republican or Democratic issue. It was not a conservative or liberal issue. It was a human rights issue. It was a civil rights issue. It was a constitutional issue. Republicans and conservatives, at least as much as liberals and Democrats, ought to have a loyalty, respect for the Constitution, and a recognition that it is the Constitution that protects us all. And so we thought that by combining this, we would be able to make the point that this really was an issue that ought to be looked on the merits, and not from a political standpoint, not from a partisan advantage standpoint, but just looked at from a constitutional standpoint.
Well, as you look at that, I'm glad, David Boies, that on a couple of occasions you've alluded to history. You mentioned that in your mind, what you've done recently is connected to the civil rights struggle of the 1960s. We talked about an event with Mayor Newsom in 2004. A lot has changed in this country just since 2004. And that is a good reminder that these rulings are part of a very long process that is by no means over, and that we cannot predict really the end of. We can't predict, perhaps you can, but I will
I'll predict the end. I won't predict when it happens, but I will predict the end.
Why don't you do that, and we're going to analyze why you know that.
I think that this issue has been decided. It hasn't been decided in a way that's binding on all 50 states. But if you look at the principles that the court articulated, not only in the district court decision that we have in the Perry case, but also in the majority opinion in the Doma case, in which the courts hold that there is no rational basis for this discrimination, that this discrimination offends constitutional principles of equal protection, due process, liberty, the right of association, all of the principles that has led the Supreme Court in case after case after case to hold that states cannot limit the fundamental right to marry. The court held that in Loving against Virginia in 1967, when Virginia banned interracial marriage. And they argued that this determination of who could get married and under what circumstances was something that ought to be left up to the states, been traditionally left up to the states. Supreme Court said no. Marriage is such a fundamental right that states don't have the right to discriminate against one group of citizens or in favor of another. Wisconsin passed a law, kind of interesting law, that said if you've had one marriage and you screwed it up, you don't get another marriage license. Now, you had to screw it up pretty badly. You had to be abusive, or you had to be a child support scofflaw or something serious like that. But if you seriously abused a first marriage, you weren't entitled to another marriage license. Rational, sensible policy. You can agree or disagree with it, but there are certainly policies in favor of it. The Supreme Court said Wisconsin may have a legitimate goal here, but the right to marry is such a fundamental human and civil right that the state cannot limit it, even for good reason. And of course, in our case, one of the things we demonstrated at trial, and demonstrated not only through our witnesses, but through cross-examination of their witnesses, was that there was no rational basis that supported discrimination in terms of who could get married.
So when you read the two majority opinions that have come out this week, you see justices, 5 justices, and they're different 5 in each case, if I'm not mistaken, signaling principles under which, especially the DOMA case, under which ultimately you think a case is going to become before them, they're going to apply those same principles again and widen what they have already done. This is a situation in which Antonin Scalia agrees with you. I've been reading the minority opinions, the dissenting opinions on these rulings, and Scalia is one of the most eloquent conservative justices, as many, if not all of you know, and he notes that the majority in the Defense of Marriage Act case has a sentence in which they say this only applies to California. And Scalia does not actually use profanity, but almost sounds profane. And he says, the only thing that will confine the court's holding is its sense of what it can get away with. And he goes on to suggest that there was something a little dishonest about the Defense of Marriage Act ruling because they should have just gone ahead and declared the right that they were trying to declare. It sounds like you and Scalia, even though you might phrase it differently, are in very much the same place.
Well, I think we are, because I think anybody who reads that opinion cannot conceive of that court holding that a state could discriminate against a class of its citizens in determining who they could marry. I think that as a matter of constitutional jurisprudence, the court in the Doma case and the court in the Perry case made a sensible step of going only so far as they had to go to decide that case. It's frustrating. It's frustrating to me. It's frustrating, I think, to the general public that courts don't jump ahead and decide the cases that need to be decided, even if they're not squarely in front of them. But there's a long history of constitutional restraint in which courts try to decide constitutional questions as narrowly as possible. And I think that's what the court was doing here. But the principles are very broad principles. And as Justice Scalia recognizes, those principles lead inevitably to marriage equality in all 50 states under the Due Process and Equal Protection Clauses.
But let's note, you have said that these rulings effectively affirm the right to marry, but they explicitly do not affirm that. I mean, that's
no, they affirm the right to marry. What they say, however, is that until you are presented with a case that tests whether a state other than California, because California was the only state in the Perry case, has the right to restrict marriage. That's not a question that they have decided. They haven't decided the question, but the reasoning, the principles that they articulate are reasoning and principles that can lead to only one conclusion. And the majority recognizes that, and even Justice Scalia recognizes that.
Let me ask about a little more of the dissent, because we're talking about cases that were decided but not decided. Everyone agrees there will be more cases, perhaps between the identical 9 justices or most of them. Samuel Alito, in his dissent in the Doma case, says that the other side cannot claim that same-sex marriage is a fundamental right under our Constitution. He says they cannot claim that, you cannot claim that. So the other side went for this equal protection clause and other things. He goes on with some other language. Is he right about that? You cannot claim that?
That's the question. That's not the answer. There's no legal reasoning there. He doesn't say they can't claim that because. He doesn't say you can't make this claim because there's this case out there. He doesn't say you can't make this case because there's this legal principle out there. He doesn't have any more reason than the proponents have. I've said a number of times, including 3 years ago in this venue, that this is a unique case for me. One of the things that I think makes me a good lawyer is that I'm pretty good at figuring out what the best arguments are on the other side. And that's important because that allows you to come up with answers to them. Here there isn't another side, there isn't another reasoning. There's no legal reasoning, there's no factual reasoning. The other side's got a bumper sticker. It says marriage is between a man and a woman. Or another bumper sticker that says there's no constitutional right to this. But there isn't any reasoning there. There isn't any justification in there. There's no rationale for why you come to that conclusion. The other side has a conclusion, but they don't have any support. And that's why they lost so badly in the trial, and that's why they lost in the Supreme Court, where even the dissenting justices can't say this decision is wrong because of A, B, and C. They just say in very passionate terms and repeatedly, the decision is just wrong. That's not legal reasoning.
Okay, can you claim that same-sex marriage is a fundamental right under our Constitution? To pose that question that Samuel Alito raises.
Well, not only can I say that, but the Supreme Court has said that over and over again. The Supreme Court has said marriage is a fundamental right. They said that in Loving. They said that in the Wisconsin case. They said that in a case involving Missouri, where Missouri said that if you're a felon in prison for life, you can't get married. The Supreme Court said, well, you can't do a lot of the things that married couples generally do, but even though you can't have physical contact, the right of to marry is so fundamental to human dignity and liberty and association that the state of Missouri can't prevent imprisoned felons from getting married. Now, if you can't prevent imprisoned felons or scofflaws or wife abusers from getting married, I think it follows pretty clearly that you can't prevent loving, law-abiding citizens from getting married because of their sexual orientation.
Let me ask, go ahead, it's fine. Let me raise one more thing because people raise it.
Yeah.
Can the courts prevent 3 people from getting married?
If they want to, and a state says that because you're not discriminating against any class of citizens. Now, they couldn't say white people can have 3 spouses, but black people can only have 1. The state of California couldn't say heterosexuals can have multiple spouses, but gays and lesbians can only have 1 spouse. You can't discriminate against citizens. You can have a rule that applies to all citizens. For example, you can have a rule that says marriage is only going to be between 2 people. But that rule has to be applied to all citizens. You can't just say it's going to apply to certain citizens. Now, in addition to that, there are some substantial rationales for why you limit marriage to 2 people. There's a substantial body of psychological, sociological studies that indicate that there are a number of problems in terms of raising children and spousal abuse that tend to be associated with marriages that have more than 2 people in them. That's why one of the things that we set out to do in our trial was to prove 2 factual predicates. One was that preventing gay and lesbian couples from marrying seriously harmed them and seriously harmed the children that they were raising. And second, that preventing gay and lesbian couples from marrying did not help anybody. It did not advantage anybody. It didn't protect anybody against anything. And we proved those 2 things, not only through our experts who were academic and recognized worldwide as experts in psychology, economics, sociology, but we proved that from the witnesses that the other side brought on cross-examination. On cross-examination, the other side's own witnesses confirmed that depriving gay and lesbian citizens of the right to marry seriously harmed them and seriously harmed the children they were raising, and that they had no evidence, none, that anybody could be harmed by this.
I wonder if you would argue that in the Proposition 8 case that the Supreme Court, it sounds like what you're telling me is that the Supreme Court did not dismiss it on a technicality. They actually gave the substance of your argument. You can't find anybody who can object to this.
I think that's right. They really found what is a critical part of our case, which is that there isn't any individual who's harmed by this. If there were concrete harm, then these people would have had standing. The very fact that they don't have standing is a court ruling that these people don't suffer the kind of harm that would have to exist in order to justify excluding a whole group of American citizens from the right to marry.
I want to ask about a couple of other things, David Boies, and then open it up to questions from you, and thank you all for listening so patiently. Some people may be surprised, or might have been surprised if you told them a couple of years ago that this Supreme Court would uphold Obamacare and then issue the two rulings that it did on gay marriage this week. How did it come to pass that this particular composition of judges, this composition of mostly conservative justices, would come to these conclusions?
I think you have to go back 10 years. In 2003, by a 5-4 vote that included 4 justices that you ordinarily consider to be liberal and Justice Kennedy, the Supreme Court, in really the first major civil rights decision involving gay and lesbian rights, held that states did not have the constitutional power to criminalize homosexual conduct. And they held that in an opinion written by Justice Kennedy, in which he talks about how the government, neither a state government nor the federal government, has any right to enact discriminatory laws based on religious principles.
There's wine there if you need a beverage.
And
I noticed they took away the water when they brought the wine.
And a very excellent wine, I will say.
Anyway, go ahead. I'm sorry.
But there was just no basis that for discriminating against people based on moral disapproval or religious principles. And that decision really informed the decision that Ted Olson and I made to bring this case in federal court.
That's why you felt you knew that you could get 5 votes. Because Kennedy was on that side of the issue.
And Kennedy's actually now written the 3 major civil rights decisions expanding the rights of gay and lesbian citizens. The first one was Lawrence against Texas in 2003, in which he held that Texas could not criminalize homosexual conduct. The second opinion came out of this state. It was Romer against Colorado. And what the Supreme Court held there was that the state of Colorado could not prevent municipalities and local governmental units from passing anti-discrimination acts. And then the third one was the DOMA decision. And in each case, Justice Kennedy articulated essentially the same bases for the holding, which is that gay and lesbian citizens are equal to everybody else. There is nothing in their conduct that harms anybody else. They have the same rights to dignity, to liberty, to equality that all other citizens have, and that the state cannot discriminate against them based on some concept of moral disapproval or some kind of religious conviction. And when you take those principles, and as I say, those principles were articulated in 2003 at a time when the country had not progressed nearly as far as it has today in terms of recognizing true equality. We were pretty confident that those principles would decide our case our way.
Why do you think Justice Kennedy was engaged on this issue in this way when on some other issues he might have gone another direction?
I don't honestly know the answer to that. I know that he is a person of tremendous compassion. He is a very conservative justice. He was in the majority opinion in striking down the Voting Rights Act. He was in the majority opinion in limiting the right of citizens to sue for civil rights violations. He has been in and he was in the minority. He was one of the people who voted to hold Obamacare unconstitutional. So he is generally a very, very conservative justice. He also voted against me in Bush v. Gore. However, he is a
Not
very...
that anybody remembers that.
Yeah, exactly.
But
But he's also a very compassionate person. And his conservatism comes from a belief in federalism, a belief in limited government, and he believes that that is the best way to promote human dignity and liberty. Personally, I disagree with him on a number of the particular applications of that philosophy, but there's no doubt in my mind that he holds that philosophy because he believes that federalism and limited government are the best way to protect individual liberties, individual rights, provide individual citizens with the right really to pursue happiness in their own ways. And so when you move from the kind of decisions where he's voted very conservatively to issues like civil rights, some of the same reasons that motivate him to be conservative there motivate him to be, I think, still conservative, but conservative in recognizing that equality and dignity and liberty are not liberal principles alone. They are principles all Americans ought to be in support of.
let me ask you also, of course, justices are supposed to rule based on the law and not on public opinion. People often wonder how the broader political situation factors in. These are rulings in which they actually note in the opinions, we're aware there's a really big public debate over gay marriage. Do you think they gave thought to that as they crafted these two rulings?
I think as human beings, they were certainly aware of it and they would certainly give thought to it. I think you're exactly right, though, that the function of judging is the function of applying laws, and particularly the Constitution, irrespective of what public opinion says. If you were going to go by the polls, or even if you were going to go by voting, you wouldn't need a written Constitution. We have a written Constitution. We have a Bill of Rights because we believe that there are certain rights that are so fundamental to our concept of the society we want to live in that no legislature, no vote of the people can take those away. It doesn't make any difference whether that vote is 52% as it was in Proposition 8 or 62% or 72% or 92%. No majority can take away those fundamental rights. And I think that that is the backbone of the decision that was rendered by the district court in our case. It's the backbone of the decision that was rendered by the Federal Court of Appeals in our case. That's the backbone of the United States Supreme Court decision in DOMA.
In these two cases, the justices effectively took the federal government out of the business of saying something about gay marriage and left the states in the business, at least for the moment, other than California, of making their own decisions about gay marriage. Was that the best possible decision? The best possible result overall?
Well, I think the best possible result would have been to hold that marriage equality was required in all 50 states. I think from a jurisprudential standpoint, that was a hard decision for them to reach because that wasn't raised in the DOMA case. And if you conclude, as the justices concluded, and I think correctly concluded, that there was no standing, they could not reach the merits.
But this gets to my question because, of course, one of the strategic questions that people have, and not just strategic, philosophical questions, is whether this should be decided by the political process or in a court. You're saying you're okay with it being finally decided in a court?
Well, it has to be decided by the court if it's a constitutional question. You can't allow constitutional questions to be decided by the political process. If you did, Virginia would still have bans on interracial marriage, or certainly would have had for decades after 1967. If you allowed segregation to be determined by the political process, Georgia and Alabama and Mississippi, where you had to send in federal troops to desegregate schools, would not have adopted that racial equality. So the whole point of having a written constitution is that you don't allow certain rights to be determined by the political process. We don't say we're going to let every state decide whether they're going to have freedom of speech. We're not going to let every state decide whether they're going to have freedom of the press. We're not going to let every state whether you're going to allow people to be imprisoned based on a refusal to testify against themselves.
But you've heard the countervailing argument, the argument that the political process is going your way, that public opinion is going your way. Let that continue happening. Don't short-circuit it.
Public opinion was certainly going the way of permitting interracial marriage. By the time the United States Supreme Court decided Loving against Virginia, there were only 16 states that prohibited it. But the fact that there are only 16 states that prohibit it doesn't mean that the people who live in those 16 states aren't entitled to the same rights and privileges of the citizens every place else. The reason the 14th Amendment was passed was because this country said after the Civil War, we're not going to let any group of states decide for themselves what rights they're going to give what citizens. And people talk about states' rights, and states have a lot of rights. But one of the things that the 14th Amendment said, and it said so expressly, is that those state rights do not include the right to discriminate against your own citizens.
So, we have a situation now where there are 31, if I'm not mistaken, 31 states where gay marriage is outlawed as a...
There are 37 states that do not have marriage equality. Now, there are some states that don't have any statute or constitutional amendment on the books that deal with it.
Right.
There are some states that prohibit gay marriage by statute. There are a number of states that prohibit by constitutional amendment.
So what do you do now as you look at those other 49 states?
I think one thing you do is that you try to convince those states, as 4 states were convinced in just the last election, to adopt marriage equality without requiring judicial intervention. I think you will see additional states that do that. But there probably will be states that are not going to voluntarily accept equality in the sexual orientation area any more than they were prepared to voluntarily accept equality in the racial area. And in those cases, we're going to have to bring litigation that will ultimately be decided by federal courts of appeals and perhaps by the United States Supreme Court.
You'll be involved in that?
Yes.
And so...
Yeah.
Is that process happening now? Are people now looking for test cases and other...
I think that process, American Foundation for Equal Rights, which was the organization that really supported and generated the Perry litigation, the Human Rights Campaign, which has been very vital to this whole process, I think are both looking right now at both the legislative and judicial processes as to how we move towards marriage equality in all 50 states as fast as possible.
Okay. David Boies, thank you very much.
Thank you.
This has been great. And now, all right, take a sip of the wine. It's from 1985, this wine. Many of you in this room are younger than this wine. Some of you may be a year or two older than this wine. I want to open it up for questions, and I'm going to invite people to begin right in the front. It is alleged, or maybe they're not in the front, it's alleged that there are people from the Los Angeles School District here. Is that correct? Right here. Okay, there we go. If you guys got a question, you get the very first question. We're going to get a microphone. Does anybody have a question? You better have one. You don't? We'll get to you. We'll get to you. Oh, wait, are you guys? There we go. Go for it. And please, if you would, stand up and say your name so we get to know each other a little bit.
Good evening. My name is Lydia Ramos. I am the Special Assistant to Superintendent John Daisy, who oversees the LA Unified School District. And we are proud that we have 24 of our Aspen Challenge students here who presented today. If you missed them, please see them online at aspenideas.org. My question is, as late as the mid-90s, Karl Rove and the Republican Party used gay marriage as a wedge issue in elections to bring out, basically get out the vote. With this Supreme Court decision and the movement or lack of on the immigration reform, what do you believe is the next Republican effort to get out the vote if it's not gay marriage?
Well, it's certainly not going to be gay marriage because 80% of the people 30 and under favor marriage equality. And any party that goes to war with the next generation of voters is engaged in a self-destructive activity.
The people younger than this wine are on your side. That's what you're saying.
I'm saying the people younger than this wine are almost uniformly on our side. And it doesn't make any difference what region or state they're from. Young people overwhelmingly support marriage equality. And frankly, the problem is that people who sit on our courts grew up when I grew up at a time of vicious, widespread discrimination against gays and lesbians. And judges are supposed to set those prejudices aside when they decide constitutional issues. And to a very remarkable extent, justices do that. But it's hard. And we're not entirely always successful in getting people who are older to look at this issue in the same way that people who are younger and have grown up in an atmosphere that is not permeated with that kind of discrimination look at this issue. So I think that it's clear it's not going to be gay marriage. And that was also signaled by the fact that over 100 prominent Republican leaders supported us in the United States Supreme Court. People, including the former chairman of the Republican National Committee, senators, congresspeople, governors, all supported us because they recognized probably two things. One, that we're on the right side of this issue. And second, being on the other side of this issue is now going to be political suicide. The next wedge issue, I mean, in the last election, the wedge issues were the Republican Party's war that it decided to wage on the two largest voting blocs in this country, women and Hispanics. It didn't work out very well, and they're going to have to find another war to wage if they're going to find another wedge issue. I would hope that they would abandon the idea of wedge issues. I would hope that they would abandon the idea that what we want to do is drive people in this country apart and bring them back together again. If I were to try to think about what it would be their best issue, I think it would be the economy. It would be the debt. It would be the entitlement programs that need to be reformed and brought into a sustainable mode. I've said a number of times that the Republican Party, had two self-created disadvantages: their war on women and their war on Hispanics. The Democratic Party had one disadvantage, and that is the Democratic Party is not viewed as fiscally responsible. Whichever party sheds those disadvantages first, I think is going to dominate politics for the next couple of decades. And I think that the challenge for the Republican Party is to abandon the right-wing fringe that has driven it into some of these positions. And the challenge for the Democratic Party is to find a way where we can, consistent with our principles of wanting to protect the most vulnerable people in this society, find a way to do that in a fiscally responsible way.
Okay, I know there's people in the front, but yeah, let's go over this direct. Oh, there's someone else from, okay, go ahead. Yeah, go ahead. Stand up, come on.
Hi, I'm Jordan. I go to Westchester. So my question is, if there's supposed to be a separation of church and state, why are religious views always thrown into voting on why people should be able to get married or any issue?
That's a really great question. I mean, it really is. At the end of the trial, the proponents of Proposition 8 accused Ted Olson and myself of trying to elevate science over religion. We thought that was our argument. And it is a mystery to me, and a mystery, fortunately, to Justice Kennedy and the other justices in the DOMA majority, why anybody would believe that it is the function of government to choose among religious faiths. I'm hopeful that we get back to the separation of church and state. And I think that the decisions that we've seen this week are a step in that direction.
Is it true also that there are people of faith who have used their religious beliefs and have come over onto your side? I mean, their philosophy
absolutely
leads them to you.
No, absolutely. This is an issue, even in California during Proposition 8. There were churches and institutions of faith on each side. The work that the various churches did in support of Proposition 8 has gotten a lot of attention, but there are also many people of religious faith that believed, as I do, that this is something that is more consistent, not less consistent, that love and the universality of love is really the basis for many people's religious faith, including my own. And I think that we can have very passionate disagreements over issues of religion, but those disagreements ought not to be arbitrated by the government. The government doesn't get to decide which religious beliefs are right and which aren't.
Okay, if there aren't any more questions from the Los Angeles students, let's go over here in the back. I see an upraised hand pretty far back. If there's a microphone anywhere near. Yeah, that's right. Look to your right. I think a microphone is approaching you.
Remember Jerry Bovino, Aspen, Colorado. First, congratulations on this long overdue victory. We're all very pleased with it. Secondly, the word marriage is highly polarizing to many Americans because of the excellent question and the religious connotations that it holds. I believe that consenting adults have the right to contract, and I think this is a big part of it. And my rhetorical question to you is, wouldn't it be more proper to have the state sanction civil unions between everyone, straight couples and gay couples, and leave the entire emotional question and the word marriage, and even though this is semantics, to the churches, mosques, and synagogues?
So your idea is marriage is between no one and no one else. That was your idea. No, I'm sorry. Go ahead. That's fine.
That was a question. That was the exact question that the district court judge asked Ted Olson and myself during the trial. He said, what if we simply told the state to get out of the marriage business, left marriage to religious institutions, and allowed the state to enforce civil unions with all of the child support issues and other financial support issues that are inherent in typical marriage relationships. And that would certainly eliminate the discriminatory problem. I think that the state could, consistent with the Constitution, say, we're going to issue licenses that allow you to have all of the rights and attributes of marriage in a civil context, which is what California did up until last Wednesday for gay and lesbian citizens. But we're not going to sanction certain of those relationships with the term marriage. On the other hand, I don't think that's going to happen. I think that would solve the constitutional question, but I don't think that's going to happen because I think the term marriage does carry with it such important values and such important sanctions of society and support from the community that I think people want to have the state give them that title, even if they don't want to go through a religious ceremony.
Okay, there was someone who's been patiently waiting up here. Please go right ahead, sir, in the second row. The microphone's coming right to you, and then we'll go to the back again.
I was here 3 years ago.
What's your name? Stand
Larry
up.
Wolf, I'm sorry. Okay. Larry Wolf. I was here 3 years ago with David and Ted Olson, and after listening to the two of you, I felt just absolutely great. So why did you have a sleepless Wednesday morning? And how could four justices, including the Chief Justice, vote in the negative? And aren't you worried that 5-4 could be 4-5?
And it is the latter 2 points that gave me that sleepless Wednesday morning, because I did think that there could very easily be 3 or 4 judges who would vote against marriage equality, vote in favor of DOMA, and knowing that they only needed 1, and knowing that those same 4 justices often got that 1 on a number of controversial cases, made it more sleepless than I would have liked it to be. Now, in reflection, I think what I said 3 years ago and what I have always believed was right, in the sense that the constitutional questions are so compelling that we are going to get at least 5 judges. And if we need Justice Kennedy, his compassion and his history of writing in favor of civil rights would make it very, very hard, I think, for him to reverse course at the end of his career and, in effect, repudiate, the legacy that he has established. So I think that is something that always gave me confidence. But when when you think it's going to be 4-5, and you have to keep all 5 of the ones that you need, it's something that you worry about.
Okay, let's head toward the back. There's a gentleman raising his hand right there. Go right ahead, if the microphone is close to you.
Hello, Micah, Aspen, Colorado. Back to a states' rights issue. Where do you find the Colorado voters supporting the recreational use of marijuana and the legalization of medical marijuana in approximately 15 states in America, and the Supreme Court's views on that as a states' rights issue?
Well, that's also a great question, because the only way that the Congress regulates marijuana is under the Commerce Clause. And there was a case, Lopez, in which Congress had also passed a law that said you can't have guns within a certain distance of a school. And 5 justices on the Supreme Court held that was unconstitutional, because they weren't regulating that for purposes of regulating guns. They were regulating it for purposes of regulating health and safety. Now, nobody thinks Congress regulates marijuana because they're trying to regulate, economic use of marijuana. They're regulating marijuana because they think they want to do it for health and safety reasons. Now, they may have good health and safety reasons or bad health and safety reasons, but it's clear it's health and safety reasons. It's not interstate commerce regulation. And if you believe what the Supreme Court held in Lopez, you would have to believe that medical marijuana decisions by states ought to be respected. Now, if you go to Obamacare, a majority of the Supreme Court held that Obamacare was unconstitutional because it wasn't justified by interstate commerce. The only reason it survived is that 5 justices concluded that it was justified by the power to tax. So if Obamacare and gun sales aren't interstate commerce, I don't think medical marijuana is either. The question is whether the justices will have the consistency of their convictions when it comes to marijuana. Justice Scalia, for example, voted that it was unconstitutional to regulate guns, but it was constitutional to regulate marijuana. He likes guns. He doesn't like marijuana. He doesn't like Obamacare. If he doesn't like it, maybe he thinks it's not interstate commerce. If he does like it, he thinks it is interstate commerce. I mean that a little facetiously, but there is, I think, a danger that when interpreting provisions like interstate commerce, people can decide, do I like it or not, as opposed to, is it really interstate commerce? If I had to make a prediction, I think if the trend continues the way it is now, the Supreme Court will hold that current federal regulations on marijuana, particularly marijuana that is locally grown and consumed within a state and doesn't cross state lines, is not subject to congressional regulation.
Is there somebody way in the back who can ask our last question? Is there anybody back there that I can hear? I see a hand. I can't even see the face attached to the hand. You win. Right back there. You get our last question, then I'm going to ask one more question. Because I'm the moderator, I get to do that. Yes, ma'am. She's waving. Yes, that's her. No, way back. You can get there. Waving the two hands.
Thank you very much.
Say your name.
Diana Romero from New York. Since you mentioned the attack against women, I'm curious if you can speak to why. If you can speak to why there has been such success against women since Roe v. Wade. We're 40 plus years since that, and we're still almost at the beginning. And the DOMA decision came out at about the same time that the incident in Texas was taking place. And it's very difficult to figure out where we're going with women's rights, even so many years after that decision was made.
I think that one of the reasons is that women themselves are divided on this issue. If this were an issue that women were united on, I don't think it would be a particularly difficult or even politically charged issue, because a very large number of men certainly support a woman's right to choose, and I think that if women were united in that, particularly since women represent a majority of the voters anyway, they would easily prevail. I think that unlike many other civil rights issues, when you're talking about racial injustices, the vast majority of African Americans voted for, worked for, demonstrated for racial equality. When you're talking about gay and lesbian citizens, the vast majority of gay and lesbian citizens vote for, campaign for, support equality based on sexual orientation. In the area of Roe v. Wade, the class that is protected, women, are themselves substantially divided on the issue. And I think that makes it a much more difficult issue to put to bed than the issues of racial and gender discrimination in other contexts and sexual orientation discrimination.
Last question, David Boies. I was reading a New York Times article. It was so striking I started taking notes involving a gentleman from Bulgaria named Trajan Popov, who, as I'm sure you're very well familiar, received his green card in Florida because he is married to, I didn't write down his spouse's name. He's married to a man, gay marriage. Because of the DOMA ruling, he was able to receive his green card. He was the first person to do so. The thing that was remarkable to me was that according to the article, the government hasn't even established the procedures to do this yet. They were planning to work on it next week. But, quote, eager officers pressed the button on the notice on Friday. They were so eager to get this done. As you know,
good for them. Good for them.
As you know, As you know, in California, something similar happened. There could have been a 25-day waiting period after the Supreme Court decision. It was decided 2 days was enough. People have already been married. If I'm not mistaken, your clients have already been married.
Our clients were married last Friday.
At the same time, as we've learned, this is not a debate that's over. So just give me an idea, how different is America today than it was 1 week ago, if at all?
I think that America is different. In my cross-examination of the leading expert for the defendants in the Perry case, at the very end, he admitted, after having admitted that this is a country whose values are equality and liberty and association, and admitting that those were the qualities that were pursued in marriages generally, admitted that this country would be more American the day we allowed gay and lesbian couples to marry. And I think we are more American.
David Boies, ladies and gentlemen. Thank you very much. Thank you. That was great. Well done.
I've got an observation and question. The observation is 3 years ago, my wife and I were here. You obviously don't want to break bread as much as Ted Olson. And then the question is, had California appealed so that they had standing? Now what?
I think we would have won, just like we won the gold. That would have directly presented